Again, she said, I have personal knowledge that the defendant named above is not in military service. I'm going to ask again, how the fuck do you know that? How do you know anything about us, but you don't fucking dig on people? You don't have anybody that digs on people. How the fuck do you know any of this? Or don't know any of this? But if you don't know any of this, why would you undersign under penalty of perjury and declare that the following to be true? Why would you do that if you weren't fucking sure of what you're saying? And if you are sure, how the fuck are you sure? Why are you digging on people? You know that thing you want to get on here and fucking cry about constantly? Just ask it. So the same thing, right? The following facts support my statement as to the defendant's military service. I know her personally. Bitch, no, you don't. You don't know the fucking first thing about Clue. You don't know what the fuck it would be like to walk one fucking step in Clue's shoes because you aren't even in the same goddamn universe as you would need to be to walk one fucking step in Cluminati's fucking shoes. You'll never be the fucking woman she is. You will never be fucking close to it. You will never fucking know her. Let it fucking go.
It's facts. And thank you.
You're welcome. This is the same thing here. This is so this would be, I think, the outcome of that hearing on the 6th. So yeah, it is. So this is the outcome when you don't fill out the proper fucking form for an ex parte. The judge has nowhere to give details, so they don't check anything. They just sign October 6th, 10:43 a.m. So yeah, October 6th at 10:43 a.m., the district court judge signed off and didn't make any ruling at all. And I'm left to assume that's because there was nowhere for her to list her ruling. What?
That's a good fucking. Perhaps she intentionally put East Gallatin so you wouldn't get the paperwork, as another creator did similar and was granted even though there was no proof of service.
Interesting. Well, fuck shit don't always work, especially when you put the proper zip code. Sorry.
Idiot.
So I want to go through what was filed as a result and was mailed to Brittany on 10/8. So mind you, we were served on 10/8, right? Fully served. That same day, the what you're about to see was filed in Scotland County Court and was also mailed to her.
Oh, what are you showing now?
The motions and the answers.
You said Cletus.
Yeah. So this is the motion to dismiss that was filed on my behalf. Now comes the defendant, Cletus, by and through the undersigned counsel and pursuant to Rule 12B of the North Carolina Rules of Civil Procedure, subsection 1, subsection 1, lack of jurisdiction over the subject matter, lack of jurisdiction over the person, improper venue, and failure to state a claim upon which relief can be granted, respectfully moves this court to dismiss the plaintiff's complaint. So jurisdiction over the subject matter. What my understanding of that would mean is that since we are in Tennessee, she is in North Carolina, and our only interactions have been reviewing each other's content and stating things on our own channels, anything that could be perceived as relevant to this, that's the extent of it. She filed this in North Carolina, which has no jurisdiction over that. Lack of jurisdiction over the person. So the other challenge she had is lack of jurisdiction over us because we are in Tennessee and we don't have any connection to North Carolina. That basically gives them jurisdiction. She was facing that uphill battle as well. Improper venue kind of combines those two, the way I understand it, basically because, there is no jurisdiction. The venue is not valid for it to be heard in North Carolina. Number 6, failure to state a claim upon which relief can be granted. So again, you've got to be very specific and you've got to be very accurate with the things that you say when you fill one of these out. You cannot just say my fifis were hurt or I'm scared of Big Bad Mean Clue and expect that to hold. You have to provide specifics because this is a legal filing, and with any legal filing, there needs to be specifics.
In answering the allegations of paragraph 1 of the complaint, it is admitted that the plaintiff is a resident of Scotland County, North Carolina, residing at blank, as set forth by the plaintiff on the complaint herein. The defendant denies any unlawful conduct and asserts that he has never been in Scotland County or that any alleged unlawful conduct occurred within the state of North Carolina, and that the defendant is a citizen and resident of the state of Tennessee, except as herein admitted. The allegations of paragraph 1 are denied. 2, that the plaintiff has not checked either 2A or 2B, that she is a victim of any unlawful conduct that occurred in North Carolina, and therefore the allegations of paragraph 2 in its entirety are denied. 3, not applicable. 4, not applicable. 5, that in answering paragraph 5 of the complaint, the plaintiff has not checked paragraph 5, so the pre-printed allegations of paragraph 5 are denied. And the...
Oh, my bad.
Which way do I go with this?
Here we go.
where was and the defendant's typed allegations of paragraph 5 are denied. In as much as the plaintiff did not check paragraph 5, she has therefore made no allegations, and therefore any additional allegations typed under paragraph 5, which can be construed as allegations, are hereby denied. You can go.
Oh, okay. You're right here, right? The
Yep,
action.
second
So the
defense.
second defense, request for payment of attorney's fees. The action against the defendant herein is without merit and is designed to harass, bother, and cause the defendant embarrassment and to incur unnecessary legal expenses. The plaintiff has abused the judicial system by taking out a frivolous complaint for no contact order for stalking or non-consensual sexual conduct where the court has no jurisdiction, venue, or evidence to support a claim, and plaintiff intended to take out an ex parte order which was denied by the court. As a consequence, the plaintiff should be ordered to pay directly to the defendant all of the costs of this action, including attorney's fees incurs, as well as other sanctions the court deems appropriate for a frivolous and malicious action, pursuant to the North Carolina Rules of Civil Procedure, Rule 11 NCGS 621.5, by virtue of the wrongful acts of the plaintiff. Wherefore, the defendant prays the court as follows: that all claims in the prayer for relief be dismissed with prejudice, that all relief prayed for in the complaint be denied, that the plaintiff be required to pay the cost of this action, including reasonable attorney's fees as reimbursement to the defendants for the costs made necessary by the plaintiff's accusations and as a sanction against the plaintiff, that the court grant such other relief and further relief as it deems just and proper. And again, this was dated on October 8th. It was mailed out and it was filed that day.